Well, great. My name is Andreas Glarner. I'm also partner with MME, part of the crypto team of MME, and I will be guiding through tonight's panel discussion. When we talk about TGEs, a lot of people talk about, oh, this is a legal gray zone. I personally don't really like the term gray zone too much. It sounds too dark to appreciate it. I prefer to say we're in an unregulated environment. We're in an environment where regulations and jurisprudence is still under development, so we still have a lot of uncertainties. This is correct, and that's probably where the term grey zone comes from, but I'd like to avoid it whenever possible. When preparing for tonight's panel discussion, I briefly did some Google research to find out what this blockchain looks like. Now, to kind of find out some titles where we stand in the discussion, especially when it comes to the US laws and the question whether or not tokens qualify as securities, where the current discussion is. And you find titles of articles written by not just interested people, but by renowned lawyers and professors of US law schools, like Why Crypto Equity May Not Be Security. That was one essay, very good to read. Another one, yes, crypto token cartels are classified as securities. So this is kind of the range you're in the discussion in the US. I made the same experience talking to many US lawyers. I think there's still a lot of uncertainty, and I would like to pass the word to Lee to address some of those questions with regard to US security laws.
Thank you, Andres. Look, the question is not so much a question of whether or not blockchain tokens as a whole are securities. The analysis that we've done, we worked with Coinbase and others in the industry. Coinbase published our work back in December of last year. Under the analysis that we've done, there are situations where a blockchain token could be a security, and there are situations where it's not a security. I think there's two principles to keep in mind here. The first principle is that a blockchain token is a type of property, and it's a representation of some type of underlying asset. And so the type of underlying asset that it's a representation of, or the type of property that it's a representation of, really is the important factor in determining whether or not you have a security under US law. For example, we would certainly say that a share of stock in a corporation or GmbH would be a security under US law. Similarly, we would say that a token that represents an ounce of gold would not be a security under US law. Where we look at this and where we think about this from a broader perspective, and here comes the second principle, is whether or not the token is giving you some kind of a return on your quote-unquote investment. In other words, are you getting paid based on holding that token other than by doing some work yourself? So that's not ironclad, that's not going to be the case in all situations, but that's really the way to think about it. If you just sit back and profit from holding the token, then it's probably a security. Now let me add one important caveat there. Profiting from the token because of the price changes in secondary market trading, that doesn't make it a security. The price changes in the secondary market are the same thing as price changes in the secondary market for antique cars, or price changes in the secondary market for houses, or price changes in the secondary market for gold. It doesn't matter. What matters is that the system is somehow paying you for holding the token and not doing anything else.
Thank you, Lee. When discussing this question with US lawyers and other people from the US, you always stumble over the term Howey test. So how does this Howey test, what is it and how does it come into play?
The Howey test is named after a Supreme Court case from many years ago. And there's actually a more recent case that from the Supreme Court that confirmed the Howey test. That's called Edwards. The Howey test was developed by the court because in the definition of security under the relevant U.S. securities laws, there is a concept called investment contract. And it was not clear what that definition was. So the Supreme Court of the United States in Howey set out to come up with a test to define investment contract. And that's why people talk about the Howey test, because they're really trying to look at, and again, this gets back to the second principle that I just articulated, they're really trying to look at whether or not somebody sits back and passively profits from owning the token or owning some other type of asset.
So if I understand correctly, when a client comes to you and kind of asks you for an assessment whether or not their token they're about to release would qualify or could qualify as a security, you need to understand the token and how it works, and then you could only do the assessment based on this qualification you do.
That's right. There are a couple of key things that we discuss with clients up front, and the first and foremost is the token mechanic. What is the token's function? What is its features? How is the token used on the blockchain? And when you dig into that, you can try to make an assessment of whether or not it's a security. One other thing that we did in our memo that I think was helpful and I should say, I'm not the only one up here who helped write that memo. Neha was instrumental in it as well. But when we were talking about writing the memo, one of the things that we wanted to do, because the Howey test is not especially concrete, is we wanted to come up with a group of what we called rights that we thought would make a token not a security, and a group of what we called investment interests that we thought would make a token a security. And so we do our analysis under the Howey test. We also do the analysis under this test that we came up with ourselves. And I should also note that we've had conversations with the SEC. We've given them our memo on this topic, and they broadly agree with the framework that we've laid out.